So let me ask you this, because these are things that people need to think about, right? And how would you feel if somebody wanted to spit in your face and their saliva landed in your eye? Your brother's wife didn't say, I'll see you all, and I'll let your mom know that you're all about to go to jail because you won't leave. Court is calling 2025 CR 007068, State versus DeAnthony Gordley. Can I have parties announce?
Gallery for State.
Robert Ramirez for Mr. Gordley, Your Honor.
And are you Mr. Gordley?
Yes, ma'am.
Counsel, have you received all discovery?
Yes, Your Honor.
And did you review it with your client?
I did.
Court will find that the state is in compliance with discovery. Mr. Gordley, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and sign it?
Yes, sir.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
We do.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Gordley, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, you're charged with harassment of a public servant. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand that the court were to grant your application for deferred adjudication? If for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, sir.
Counsel, has your client been able to provide you with any defenses?
Yes,
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Gordley, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen? I'm sorry, not are you a U.S. citizen, but did you they've changed the law. We're not allowed to ask that question anymore. So we have to do it in a roundabout way to make sure that you understand certain consequences. So if you're not a U.S. citizen, by entering this plea, you can be deported, denied naturalization, and not allowed re-entry into the country. Did you understand?
No.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it? According to the plea, there's $1,000 fine and the state recommends deferred adjudication. Did you understand that to be your plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State?
It is, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, there be any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 4 years. There'll be 200 hours of community service, restitution, no contact with the complainant, and no contact with 2400 North St. Mary's, the hostility management, and alcohol awareness course. Did you understand those are recommendations from the state, and the court does not have to follow those recommendations? How do you plead to the offense as charged? State, any evidence?
State offers states one in attachments.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering into this plea bargain agreement, the state will be presenting evidence in the form of witnesses' statements and police reports. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
We ask that you follow the plea agreement.
All right, and so this location, where is this location? What is the business?
Nightclub,
And what's the name of the nightclub?
Rumble,
I'm sorry, what?
Rumble.
Rumble?
This one.
And what time did this happen?
I want to say around like 2 o'clock in the morning.
Mm-hmm. So that still goes back to my point. Nothing good happens really after 10. So had you been drinking?
No, ma'am, I wasn't drinking at the time.
So you were sober.
I did drink beforehand, but at the club, I was not drinking.
No. So were you sober?
No, ma'am.
So you were intoxicated.
Yes, I was.
So why didn't you leave when they wanted you to leave? The clubs, do they close at 2 a.m.?
I think they were closing.
There was a lot going on.
All right. What does that mean? A lot going on. Somebody asked you to leave a location and you don't leave.
We were actually leaving, and it just it was a fight going on. And
Between?
a lot of us. There was so many people out there I can't even remember for real.
So do you know these other people? Devontae Manquel, German Scott?
Mhm.
Who is he to you?
It's my cousin,
Sergion Jarrell Knowles,
my brother.
Amy Arlene Garcia,
I don't know.
Serena Faith Estrada,
Brother's wife.
Anderson DeAndre Sledge the fifth.
That's my oldest brother.
So let me ask you this, because these are things that people need to think about, right? How would you feel if someone were to spit in your face?
I feel bad.
And how would you feel if somebody wanted to spit in your face and their saliva landed in your eye?
Nobody else would feel.
And how would you feel if somebody spit in your face and their saliva landed not only in your eye, but it went in your mouth?
Like it.
Well, would you calmly just walk away, or would you be prepared to fight?
I'll be prepared to fight.
All right. So this officer in this report says you spit on them,
Mm-hmm.
and being intoxicated is no excuse to behave badly when people are telling you to leave their location and it's 2 a.m. and everybody probably in your group is drunk. Was there not one sane, sober person in your group to say, let's leave, you all are acting crazy? Your brother's wife didn't say, I'll see you all and I'll let your mom know that you all are about to go to jail because you won't leave?
Mm-hmm.
And do you have any children?
I have a daughter.
How old?
One.
One. So you have a daughter who is one, and who was taking care of your daughter?
Her mother.
All right. And are you and the mother together? All right. So how do you think this is for your daughter? Her father is out at 1 a.m. I'm sorry, really 2 a.m. at a club. And how old are you?
26.
At some point in time, isn't it time to be done with being out at the club at 2 a.m.?
Yeah.
And your brother and all these other people, how old are they?
Honestly, I don't know. People with their ages. I got 11 brothers and sisters.
All right. So you have 11 brothers and sisters. So these brothers that were with you this night, are they older or younger?
One of them older. They're my oldest brother, and then the other one is younger than me. He's actually 25.
So he's 25. So then the older brother who is older than you, estimate, what is his age?
30, 32, I want to say.
And still acting silly. And is your mom
She's deceased.
and your father?
Deceased.
So who is telling you all not to do this?
Nobody, honestly.
All right. So you're at that age, and I'm sorry that your parents have passed, but you're at the age where nobody should have to tell you this. Usually they say it takes males a longer time to mentally develop. But at the age of 26, you should already be there. And especially since you have a daughter who is dependent on you financially and you're not doing good things.
You made a mistake?
No, not a mistake. You made choices.
I did. You're
Yeah. Because you all chose to go out. You all chose to drink to intoxication. Y'all chose not to leave an establishment when it's already after 2 a.m. And you chose to spit on this officer. I can't even imagine how he's feeling. Can you imagine how that officer is feeling and how gross that is to have somebody spit in your eye? And not have any Visine drops, probably want to pour alcohol in your eye, but you can't. And then for it to go in your mouth. A complete stranger who's drunk. And I'm pretty sure that you all probably didn't smell great because you're drunk. You understand?
Yes, ma'am.
If you want me to follow this agreement, I will follow this agreement. But in this courtroom, probation is not easy. It's not supposed to be easy. And it's designed for rehabilitation. And what I can tell you, while you're on probation, you're not allowed to drink alcohol at all. Do you understand? Well, I mean, not that's fine. You're not allowed to. Do you understand? And you're not going to be out at 2 a.m. You should be, all of your waking hours should be setting money aside so that your daughter has enough money where she can do what she want to do, but not have too much money so she doesn't have to do anything. You understand? So the court is going to sentence you to 4 years deferred adjudication. There's going to be regular reporting by Zoom or in person. Regular random UAs. Are you currently employed?
Yes, ma'am.
What do you do?
I work at True Fit as a trainer.
Okay. Proof of employment within 30 days. No employment as a home health care provider or with minors. Do I need to go to True Fit and get in shape? See, I put you on the spot because you're like, I want to tell her the truth, but I don't want to get in trouble. All right. So there has to be no harm. Bashan, he's like, I want to tell her, Judge, hit the jam, but then I don't know how she's going to react. That's okay. I deal in truth. So there's to be no employment as a home healthcare provider or with minors. There's to be no contact with Brandon Stanley. All right, state.
Yes.
Brandon Stanley, is that somebody who's owns the club?
Yeah, it's from associated misdemeanor. So we'd ask that you follow it just because he's gonna plea on that, but not be on.
All right, no contact with Brandon Stanley or 2400 North St. Mary Street.
Excuse me.
78212. You're going to write a letter of apology to M. Ramirez. And that's the officer. You understand?
Mm-hmm. Yes, ma'am. Okay.
So other than this alcohol issue, any other drug issues with you? There's going to be 200 hours of community service restitution. I'm going to require parenting classes. Once that's completed, the community service hours will be deemed satisfied. There's going to be 30 sober support meetings in 30 days. Field visits 1 time per month for 6 months. And out of custody, you can do a TAP evaluation. If TAP recommends inpatient treatment, we'll start with supportive outpatient treatment. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, ma'am.
Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am, I did.
All right, because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. You better start making better choices. And at your age and the responsibilities you have, you should be in the house by 10. Your club days are behind you. You understand?
Yes, ma'am, I do.
All right, good luck to you.
Thank you.
You're welcome.
Nothing gang related, but a lot of them are just money. Really, all of it is really money.
All right, I'm gonna have you evaluated for gang affiliation. You understand?
Just if I'm being honest, I thought that point in time, I was using drugs.
Yes, please be honest.
I was using drugs at that time, so I was high at the moment. And I got paranoid and I left.
In this gripping courtroom hearing, 21-year-old Noah Castillo pleads no contest to evading arrest with vehicle, a third-degree felony carrying up to 10 years in prison. The judge questions him about his drug use, tattoos, gang ties, and a weapon found in his car, before ultimately handing down strict probation with life-changing conditions. Watch until the end as the judge delivers a stern warning. One mistake could send Castillo to prison for a decade.
All right, the court is calling 2025 CR 005604, State versus Noah Castillo. Could I have parties announced? And are you Mr. Castillo?
Yes, ma'am.
All right, State, has there already been an acknowledgement or discovery on this case?
Ms. Acevedo's finishing that up right now, Judge.
Oh, thank you. Thank you. Counsel, have you received all discovery? And did you review it with your client?
I have.
Court will find that the state is in compliance with discovery. Mr. Castillo, did you review the application for deferred adjudication or community supervision with your attorney?
Yes, ma'am, I did.
Did you understand it and sign it?
Yes, ma'am.
Did you review the true bill of indictment with your attorney?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Mr. Castillo, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am, I did.
You're charged with evading a restitution with a vehicle. That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargaining agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state we're calling the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense? Mr. Castillo, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Do you understand if you are not a U.S. citizen, by entering into this plea bargaining agreement, you could be deported, denied naturalization, and not allowed re-entry into the country?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney?
I did.
And did you understand it?
Yes, ma'am.
According to the plea, there's $1,000 fine. State recommends deferred. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, Your Honor.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? Outside the agreement, the state is requesting that your community supervision be for a term of 5 years. There be a TAP evaluation, 150 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead?
No contest.
State, any evidence?
Yes, Your Honor. State moves to admit what has been marked as State's Exhibit 1 in all attachments.
No, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, that means that the state will be presenting evidence in the form of witnesses' statements and police reports. But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Judge, we were just asking to follow up with her.
All right, how old are you?
21.
All right, what's going on with all the tattoos?
Honestly, can't really say, what's going on. It's just just, the time of my life, it just, it was going a little wild.
When did you get the tattoos?
First tattoo I got when I was 13.
Okay. And the neck tattoo, what's the neck tattoo?
It's just the money sign.
All right. So what do these tattoos mean?
Nothing gang related, but a lot of them are just money. Really, all of it is really money.
All right. I'm going to have you evaluated for gang affiliation. You understand?
Yes, ma'am.
Are you employed?
Not at the moment.
When's the last time you had employment?
It's about before I came in, I was doing construction, so I said about a month ago.
And how old are you?
21.
All right. And do you have any children?
Two.
How many? Age?
2.
And are you in their life? Do you live with them?
Yes.
How far did you go in school?
Graduated high school.
All right. And so what are you planning on doing with the rest of your life?
Just, being able to support my family and just go back to work and just do the best I can.
And so with this offense, why didn't you just pull over?
I did pull over, but it was just misunderstanding with the police officer.
I mean, no, it's not a misunderstanding. They pulled you over because they said you were committing traffic violations. And I'm taking what's in the report as true because you stipulated to it. And it's obvious in the police report that there were traffic violations. They pull you over. You're sitting there, pulled over, and they ask you to step out and you take off. So why are you taking off?
If I'm being honest, at that point in time, I was using drugs.
Yes, please be honest.
I was using drugs at that time, so I was high at the moment, and I got paranoid and I left.
And then there was a weapon in the vehicle as well, in the glove compartment box.
Right.
And I'm assuming that was your weapon.
No, it was not.
Who's-
It belonged to my brother's girlfriend.
But you're the owner of the vehicle.
Weird.
Any other questions?
If I could just speak on that.
Yes. I'm sorry, one final thing. So the drugs you were using, what drugs?
I was smoking weed for the most part, and I was using ice as well.
All right. Anything other than ice?
No.
All right. Yes.
I've represented this client, or Mr. Castillo, probably at least 6 months, not longer. I mean, at least since the inception date, Judge. And what I can tell the court is that he does have a good support system. He's here. I don't know, something happened with the bonds. I think they got off, or there was an FTA with the misdemeanor. And so that's why he's been in custody. But every other time, Judge, he has been here. He's been with his brother. He's been if I can't get a hold of him, I've always been able to get a hold of one of his family members. So I know that, and we've had those conversations as far as his age, what he was doing at the time, and what he plans on doing, moving forward. I've had the conversations about his drug use. They are on him. I believe that he's sober now. He's always indicated that to me because we've had long conversations about that. Specifically because of his age and the kind of drugs that he was using. So I've talked to him at length about that. But I can tell the court that I believe that he does have a support system that wants to see him succeed. And I think that they're going to do everything in their power to help him with regard to any services that the court deems appropriate. Whether that's, attending this counseling or going here, going there. I know that they are his transportation. I know that they help with his employment, and communication.
You want to talk about leaving lifetime recovery
Yeah, so I did attend
without
lifetime.
permission?
No, I had permission to
No, I mean,
leave.
they say you absconded.
No, I had actually talked to the person there at Lifetime, and they contacted the courts, and that's how I got permission to leave.
Right, could you pull that for me, please?
Because I was attending the.
It would have been May 30th, 2025. And it would have been a 5th violation report. All right, you may continue.
So I was attending the inpatient, and I told them I wanted to switch to outpatient. So they were, I don't know, somewhere.
So you told them you would like to be on outpatient. Okay. And then you missed court when Judge Angelini was here and you were on a PR bond. So Why?
I just had a lot going on at the time, so kind of just was just all over the place, as I had said before.
All right, that was June. So that really hasn't been that far from today in terms of drug use. All right, were you able to find it? Because I know a warrant was issued for him on a violation report because of absconding from lifetime recovery. And usually when you're in treatment, they don't let you make choices of whether you want outpatient or inpatient treatment. And your attorney will tell you that because she does treatment courts as well. They usually don't give the person a choice and say, oh, we think you should be in inpatient treatment. What do you think? Oh, we'll give you outpatient treatment. Usually that doesn't happen.
So I'm aware how that might sound, but I did talk to the head person in the lifetime,
Mm-hmm.
and she gave the okay as well.
Mm-hmm. All right, so what I can tell you, counsel, so this is what I'm going to do. Probation, it's going to be 5 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days of release, no employment as a home health care provider or with minors, no unsupervised contact with minors, 150 hours of community service restitution. I'm going to order parenting classes. Once that's completed, 50 hours of the community service hours will be deemed satisfied. If you enroll and complete some higher level of education or either trade school certification, the court will deem the remaining 100 hours satisfied. So you can either get a trade in something.
Yeah, so I actually, sorry, I did go to a trade school. That's how I got my high school diploma.
Well, you'll need to,
Get that.
you can work 100 hours of community service restitution, or you can get some higher level of education or trade school certification. And since you already have your high school diploma, that's not going to count towards that. You understand? I'm going to want a referral, and this is to take place in custody. I'm going to want a referral to felony drug court, and counsel, if you can talk with them. Since it's Monday, they'll probably be able to see you before the week is out and let us know whether or not you accept it. You need to be honest with them, because if you end up testing positive or violating conditions on this probation, you're potentially looking at 10 years in the prison. You understand?
This one.
So in custody, I want a referral to felony drug court. And I'm going to want a TAP evaluation and probation. I think we discussed this previously. The gang evaluation, that takes a while, correct?
No, the gang evaluation, very much, but in addition to the gang evaluation, there's something weird.
There's something going on in there. They need to change the filters.
I do make an evaluation.
Okay, so gang evaluation and ISP evaluation, and counsel, if they say with the gang evaluation he doesn't qualify, then they'll just do ISP. There'll be field visits one time per month for 8 months. Probation, $1,000 fine, that will be prorated. Is there anything else that's needed?
Okay.
Is there anything you need from the court to be successful?
No.
Did you review the document entitled Trial Court Certification of Defendants' Rights to Appeal with your attorney? Did you understand it and sign it?
This one.
All right, because this plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
This one.
All right, we can go off the record. Here's the thing. Because you're on probation, you're not allowed to have weapons. So you're not allowed to have possession of guns. If you have guns in your house, then you need to make sure those are safely stored elsewhere because you're not allowed to have possession of them. And your attorney will speak to you about that. Do you understand? In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel they're not addressing it, you can come back to the court. With regards to these evaluations, if you're dishonest with felony drug court and say, oh, no, I don't have a drug problem, you know what's going to end up happening? They will send me an email and send the court an email stating that you've been rejected because you say you don't have a drug or alcohol problem. That will be noted on the docket sheet. And what that means is don't come back here saying that now I have a drug or alcohol problem. You understand? All right. Good luck to you. You're welcome.
Do you think that that is custody or out?
In custody.
Good morning, Mr. James.
I know. I was supposed to be here yesterday, but I didn't know my court date. I thought I was supposed to be on the 25th. And I called the court.
Okay, I will reinstate your bond today.
Now I called the court, and she told me here this morning. So I had to catch 2 buses. I catch 1 bus.
There's no need for you to say anything. Just don't miss court again.
Yes, sir.
Sir, you're charged with assault, bodily injury. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
I'm sorry, but there's a call from my computer.
Excuse me on it.
We have to do probable cause.
Oh, yeah.
Just, you have the right to remain silent. I don't want you to say anything because I don't want you to hurt your case anymore, okay?
On March 13th, 2025, at approximately 3:11 a.m., officers were dispatched to a gas station in Houston, Harris County, Texas, in reference to an assault. Upon arrival, officers met with the complainant, who stated the defendant assaulted him with his arms. The complainant stated he was at the gas station when an unrelated suspect started beating on him. As he was getting beat up, the defendant jumped onto the complainant and started beating on him as well. The defendant struck the complainant with a closed fist and strangled the complainant from behind with his forearms in a chokehold for 5 minutes. The complainant passed out. The complainant stated he felt pain. The complainant pointed out the defendant, who was across the street, and the officers attempted to detain the defendant, and the defendant resisted. The complainant positively identified the defendant. The complainant and the defendant are acquaintances through the complainant's girlfriend. The complainant had a bruise on his neck and a bump knot on his cheek. I have spoken to the complainant. So from what the complainant has told me is it is
Sir.
consistent.
Move.
It's consistent with the rip, but then also this other suspect apparently had fired at their vehicle while the defendant was being detained, and there's an ongoing aggravated assault along with this as well for the other suspect.
You know who that is?
Yes, I've gotten his name. I need to reach out to the officer to see what the status is on that, but we do have the name of the other suspect.
Mr. James, I'm going to find that there's sufficient probable cause to go forward with your case. If I find that you put hands on anyone in this life from now on, I'm going to revoke your bond and I'm going to make it so high you'll have teeth falling out. Do you understand?
Yes, sir.
You are not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using alcohol or illegal drugs, I will revoke your bond and put you in jail. If I find that you're a danger to my community, likewise. No more PR bonds.
Yes,
Do you understand?
Yes, sir.
You are not to have any contact with this person. You're not to go within 1,000 feet of this. Was it a gas station?
Yes, it was a gas station, Your Honor.
This gas station, and I'm going to put an ankle monitor where I know where you are at all times. You just had 2 aggravated assaults and a burglary of a building
And I didn't,
not months ago. So,
John,
Mr.
I had
James.
nothing to do with this.
I want you to understand something. I will protect my community at all cost.
Stop.
Do you understand?
I understand that, sir, but I
I don't.
touched nobody. I broke the fight up between
Here's
this
what
guy.
we'll do. Here's what we will do. I will give you a lawyer today. We will wait for this evidence to come in. There's always two sides to a
Yeah,
story.
the officer said they need the film from the gas station. That exonerates me,
I want you to listen.
sir.
There are always two sides to a story. And the evidence will point to whose side is correct. We are giving you the benefit of the doubt, and this is why you are out in the free world as it is now. But if I find that you become a danger to my community, if I find that you pick up a new case, if I find that you break any of these conditions that I set forth, you know what's going to happen. Do you understand?
Sure.
I don't want to hear this. I don't want to hear that. It doesn't matter to me. All what matters to me is going forward, what happens. And I want my community safe.
Understand.
Judge, can we also get a residential restriction for him not to be able to go near the complainant's residence as well? Because from what it sounds like to me, they all know where each other lives.
No, I don't.
So,
When I say I don't want you to have contact with the complaining witness in this case,
Can I just say one thing? Your
hold
Honor?
on. It is a Mr. Hernandez. When I'm telling you I don't want you to have contact with this person, it's phone calls, text messages, social media, where this person lives, where this person works, where this person hangs out. If I find that you are anywhere near this person, then I will revoke your bond. Do you understand?
Yes, sir.
And here's the rub, is that if I make your bond $5,000 to $10,000 or $15,000 and you don't have anyone to make that bond, you will be stuck like Chuck until this case is over with. All I'm asking you to do now is keep my community safe and don't go near this person.
I don't communicate with this person. I ain't touching nobody, Your Honor. I was breaking this guy.
Stop. I will give you a lawyer today. You can tell your side to the lawyer, and then you guys can come up to an agreement. I don't need to be involved at this
Yes, sir.
time.
But the officer told me they could.
Stop. I don't want to hear it. You have the right to remain silent. Exercise that right. You are not to be in possession of any weapons, no alcohol, illegal drugs, random testing, a GPS monitor, and no going within 1,000 feet of where the person lives or doesn't work. Do
I don't even communicate with the guy.
you mind appointing Miss? Okay, I'm now going to give you a lawyer. You will be able to speak to the lawyer, and then you guys can come up to an agreement. You must remain in contact with the lawyer. If the lawyer tells me he cannot get a hold of you because you're ducking and dodging phone calls, I will issue a warrant. Do you understand?
But Your Honor,
You can talk to him. He'll be here shortly, and then you can tell him what happened. All right? Okay.
All right.
Okay.
Thank you, Your Honor.
We're good.
Okay, thank
you
you.
know,
Yeah. Come on, let's get this.
I had nothing to do.
I'm mad than anything else. I would like to reapproach, Your Honor, on Mr. James. Mr. James has some questions about the probable cause, and if it's possible, I'd like to have probable cause read while I'm here with him so that I can communicate to him adequately everything that's going on.
Okay.
Thank you.
Come up, Mr. James. He's saying there's no probable cause.
Sure, Honor. I think at this point, I'd like to just say that he's not fully understanding or appreciating the magnitude of what's going on so that we can communicate effectively. I'd just like us to have the transparency.
Absolutely.
Thank you, Your Honor.
You ready?
Yes, sir.
Okay. You are charged with assault causing bodily injury. You are facing a year in jail and or a $4,000 fine. She's going to read what happened in this case. Please.
on March 13th, 2025, at approximately 3:11, officers were dispatched to a gas station in Houston, Harris County, Texas, in reference to an assault. Upon arrival, officers met with the complainant, who stated the defendant assaulted him with his arms. The complainant stated that he was at the gas station when an unrelated suspect started beating on him. As he was getting beat up, the defendant jumped onto the complainant and started beating on him as well. The defendant struck the complainant with a closed fist, then strangled the complainant from behind with
Okay,
his
hold
forearm.
on. Did you hear what that said? Did you hear that?
Yeah, I know that's not true.
Okay?
Well, that happened, that's what they're saying happened. That's what the
That's
judge wants.
why we have evidence. Evidence points to whose side is correct. I know that you're saying it didn't happen.
Said that.
But the,
Somebody said that. That's the probable cause.
We have film.
I got that's right. We're gonna work on it. Just listen.
With his forearms in a chokehold for 5 minutes. The complainant passed out. The complainant stated he felt pain. The complainant pointed out the defendant who was across the street. When officers arrived, the officers attempted to detain the defendant and the defendant resisted. The complainant positively identified the defendant. The complainant and defendant are acquaintances through the complainant's girlfriend. The complainant had a bruise on his neck and a bump knot on his cheek.
And Your Honor, of course, he doesn't have a bump on his cheek or his neck, and they got the wrong thing. They got the wrong guy.
Yeah.
We're gonna prove that. So, but right now, Your Honor, do you find probable cause? Judge found probable cause based on that. Now we're gonna fight this, okay?
okay.
Okay, now listen, now we got one more thing to take care of. Your Honor, I understand that as part of his bond conditions, the court is requesting he has an ankle monitor. Your Honor, we understand that the purpose of bond and the conditions are to ensure his return to court. I have talked to him and we'd like to make his next appearance required, Your Honor.
Okay.
We would ask that he not have to have that ankle monitor, Your Honor.
And the state would be opposed, just due to the complainant's safety and the threats to their life that happened, that was relayed to us during this incident. I don't know how him and the other suspect are involved. The state would be opposed to not having him be involved.
And if I may, Your Honor, my client was not the initial aggressor. The facts are uncontroverted that my client, it was introduced to a scene of combat. Whether or not he was trying to break it up and help and it was a misinterpretation, or he actually hit this person who was ultimately unconscious and their recollection could be questioned. Those are all factual questions, Your Honor. He's contesting that he was a good Samaritan, Your Honor, and we'd like to prove that. But there were other facts that took place that were not my client. We would ask that even though they have concerns, he is not posing a risk that he would not return to court, Your Honor. And that would be the reason for the ankle monitor.
My fear, and after looking at his criminal history, he has extensive criminal history dating back to 1987.
Yes, Your Honor.
In fact, he just did 300 days on a burglar of a building not just a couple months ago, where 2 aggravated assaults with a deadly weapon were dismissed.
Yes, sir.
So my fear is I don't want him using alcohol, illegal drugs, and I don't want him anywhere near the complaining witnesses. And I want to ensure that this doesn't happen. So that's why I put this on. If after some time passes where there are no issues, I'm always happy to revisit. But for the time being, I want to ensure that our community is protected and that the complaining witness is also protected. I mean, we have here an allegation where he was choked for 5 alleged minutes until he passed out.
No, that never happened.
That's right.
The evidence will point to whose side is correct. I'm assuming, and I would hope, that if this is the fact, that officers would take pictures, there should be ligature marks, there should be all kinds of, so we'll see. I don't know. But the only thing.
Right, they don't have it right now. Yep. Yes, sir.
That's why-
You need to listen.
Mr. James, you also need to understand that you need to be patient.
Listen,
Rome wasn't built in a day. It takes time to get evidence. They don't get it immediately. It may take 6 months to get a 911 call. I don't know. But it takes time. So please be patient and don't take it out on your lawyer. He's trying to do the best he can. All I'm asking you to do is don't use alcohol, illegal drugs, and stay away from this person. Don't pick up any new cases.
Say yes. I say yes.
listen,
Can you stay away from the person?
I don't be around.
And I don't want you to go near I don't want you to go where the gas station was. I don't want you to go to their house. I don't, nothing of this nature.
Can you do that?
Yes,
Tell the judge you can do that.
I can do that.
There you go.
I don't
That's it.
communicate.
That's it. You can do that.
That's all I'm asking.
Okay.
Okay.
Thank you, Your Honor.
All right, Mr. James, good luck, man.
That's what I'm yelling. Truth about this.
All right.
I'm
Come on.
breaking nibble.
You need to sign it. This is right here. Right here. Your Honor, it's okay. I'd like to come back maybe off docket, maybe 2 or 3 weeks, even though we have a setting out till May on this matter, just for the justice.
I would like you guys to also do a RIP, make sure that there are no issues, so just be aware. So, Alan,
Yes, sir.
just give them a heads up
Yes,
when
sir.
you want so that they can have a RIP done, to make sure everything's.
Absolutely. Thank you, Your Honor.
This courtroom showdown has it all. A defendant begging for a new lawyer, a judge delivering a fiery reality check, and a shocking debate over whether dealing drugs deserves a second chance. What happens next will leave you speechless.
All right, so where are we on this case?
Your Honor, we're here for two purposes now. The first one is we've subpoenaed some witnesses. We were trying to get to the bottom of some answers regarding a videotape. But before we go there, my client has asked me to let you know he wants to renew his request for a new attorney. So I might have let him
I
address
had
it.
put in a motion.
All right, let me ask you this.
This one
Is your counsel hired or appointed?
is appointed.
All right, are you going to hire an attorney?
I'm trying to.
Well, I
I
mean,
asked him, it's because every time I ask him to do something, he does the exact opposite. I asked him back in September to please get me my bond reinstated so that I could bond out and pay for a lawyer.
Mhm.
And he never did it.
all right, so let me explain something to you about the state of legal services, right? For some reason, attorneys, people think they can do an attorney's job, even though they didn't go to school to be an attorney. And the reason why I say this, listen, you have 2 ears, so listen. The reason why I say this is because people think that all attorneys do is talk, which we do, attorneys do talk a lot. But behind that conversation is a lot of education that they've had to get. And when you compare us to doctors who are doing surgery, you never see a patient going to their doctor if they need heart surgery and telling their doctor, you know what, I know this is the way you say you're going to do the surgery, but I want you to do the incision this way. You know why they don't do that? Because, hey, I'm not a doctor. I don't know how to do incisions. But for some reason, people who have attorneys think that they're an attorney and they want to file a bunch of motions, don't know what the motions mean, because you may file one motion, but there are other things that go with that motion. It's sort of like when people read the Bible and they say, oh, I know the Bible, and they don't realize what you've read in the first book, there is something that goes with that that's in the second book, and you have to combine all of that. So if your attorney hasn't filed a motion, it's probably because you don't need that motion filed. I used to always get, you haven't filed my discovery motions. Where are my discovery motions? And I'm like, state has to turn that over. What? I'm filing a motion and the state is going to say, oh yeah, we turned that over. So that's where we are. And where we are is you're indigent. This is the attorney that has been appointed to you. And what I can tell you about attorneys appointed to represent people, there are certain qualifications that they have to have in order to represent people on certain cases. This is a felon in possession of a firearm. What I can tell you, your attorney is qualified to handle this type of case. Otherwise, he would not be appointed to this case. So if you wanted another attorney, you need to retain another attorney, period. Court is not appointing you another attorney. This will be your attorney. If you speak to him, great. If you don't speak to him, you will probably end up in jury trial with an attorney you have not spoken to. It's completely up to you. Do you understand?
Yes, ma'am.
And as a client, you have control over certain things. Whether or not you want to go to a jury trial or not, whether or not you want to testify, whether or not you want to accept a plea. You are not in control of trial strategy. And trial strategy is similar to that doctor that wants to do a heart surgery and you're trying to tell them, well, this is the way you should do the heart surgery. That's similar to trial strategy. And you're not control over that because you don't have the degree and the experience to do it. You understand?
Yes, ma'am, I understand.
All right. So where are we?
Your Honor, we are back on a discovery issue, and just briefly to summarize, there was a video and audio from the Alamo Heights Police Department. Originally, we asked for it and it said it didn't exist. Eventually, we subpoenaed Alamo Heights in. They were not able to answer the court's simple questions as to
Yes.
when the video was destroyed, what is the policy? Are the videos 30 days, 60 days? I have anecdotal evidence that it's 6 months, but anyway, that's not on the record. So they gave us 4 names for Barcom. Barcom is a company, local company that is their IT company. As the point of contact who could answer all those questions. So I subpoenaed, but they couldn't tell us who there. So I subpoenaed everybody, and then they contacted me yesterday. They said, I don't want to cause any disruptions. I just want somebody, can you tell me if there's somebody there who can answer these questions? There isn't. They just sent somebody today by I had made an agreement with them to release everybody. They sent their CEO. He's here to testify. He's not going to be able to answer the court's questions. What he told me was, and he's back there.
Well, let's bring him up.
Yes.
Let's find out who can answer these questions. There are specific questions. I remember this case that are needed to be answered. Do you know who can answer these questions? Who do we need here to answer these questions?
The people who set it up, it's a company by the name of Big State. They are the ones who installed the camera system. They would have configured how long each of the cameras would overwrite, kind of like a VHS video, right? There's only so much space.
Yes.
And how often each one of those would be overwritten would have been set up by them. Our job is to, we're users of the camera system.
Yes.
We turn into the people that can go in and pull video, get the software on computers to access the video, but we don't manage it. It's a gray area, right?
Do you have information that you can impart to the state and defense about who they need to contact so we can find out, 1, if the video was destroyed, 2, when it would have been destroyed, and 3, what is the time frame that videos are allowed to remain before it's a plea of guilty on October 13th to the offense of possession with intent to deliver a controlled substance, penalty group 2, 400 to 400 grams. According to the agreement, punishment is to be assessed at 10 years in the prison. State opposes deferred adjudication. They're recommending community supervision, and there are some cases that have been taken in consideration. Have both parties had a chance to review the PSI report, state?
Yes, Your Honor.
Defense?
We have, Your Honor.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
No objections, just a minor correction, Judge.
All right, correction.
Just the represented that he was minimizing his guilt. I'm not sure exactly why. Then maybe they felt that way. Mr. Ayub didn't recall perhaps the baggies and the scales. That was quite really just an honest answer. He is accepting guilt. He pled guilty to this offense. He is prepared to accept the responsibility for that, Judge. And I just don't want the court to believe that he wasn't intending to take any responsibility for this.
Okay. All right, state, any witnesses from either side?
No, Your Honor.
State, you're opposed to the application for deferred adjudication?
Yes, Your Honor. I'm not sure. I know the defendant is asking for deferred. This is a first degree felony though. So if he does screw up on supervision, I feel like we're setting up failure if he does get the deferred, Judge. So that's a long time he's looking at if he's unable to live up to the obligations of probation, Judge. So that's the main reason I was opposed to deferred, Judge. The other thing is these are a lot of charges that I know we're just pleading on the one, but we're taking into consideration several charges, Judge. And the one he's pleading on is the possession with intent, but this is more of this is a drug dealing charge rather than a drug using charge. That's the reason for the opposition to deferred, Your Honor.
All right, why should I give him deferred adjudication for dealing drugs?
Well, Judge, there are a number of things that I would like to address. He is taking responsibility for intent to deliver. There was a significant amount of pot-related items. I will just remind the court that it is THC-related items. He did use some for personal use. He's not denying the fact that there was times in the past where he has sold marijuana to people, but he had no intent that day. I think that's why maybe they thought he was minimizing his guilt. He was just going to enjoy his day with his girlfriend, got caught. He wasn't intending to sell anybody that day. I know it's a nuanced, Judge, but a lot of this was for personal use. His previous history, as you can tell, Judge, is cannabis related. The PSI indicates he has a cannabis dependence. I think he is clean now. I think he will continue to test clean, Judge, but they are all misdemeanors. He doesn't have any prior felonies, was never given a felony conviction, placed on felony supervision. I do understand that he picked these up over 2 different offense dates in short order. He really has no excuse for that other than he was making poor decisions. He wasn't taking in the grasp of what could happen to him should he get caught for this. He really just wants to apologize. And I would like him to give a short statement to you why he should be given deferred.
All right, can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record.
Theodore A.
All right, if you're drug tested today, what are the results going to be? And you will be drug tested today.
Negative, Your Honor.
All right, let's do a drug test.
Okay, Judge.
And then I'll come back and I'll make my decision.
Thank you, Judge. May I be excused shortly and I'll be right back
Sure.
as well.
Do you
Thank
need any water or anything?
Yes, ma'am.
All right.
He did use the restroom this morning, Judge. I was
Okay.
with him when he excused himself.
Sure.
Thank you, Judge.
All right. All right, were you able to provide a UA sample yet? Oh, there is a water fountain in the hallway. We'll get a cup of water for you. So we were here and I had asked for a UA to be done. Probation, was the UA done?
Negative, Your Honor.
Okay. All right. Is there anything else anyone would like to say?
Just briefly, Judge, I think
Sure.
his negative test shows that he is going to take this serious. State's argument that perhaps deferred would be setting him up for failure is a fair argument, but I don't think so for Mr. Ayub. I think showing that he's negative, he's taking this very seriously. He works hard. He helps his girlfriend take care of her children. He'd like to start his deferred, put this behind him, and hopefully there'll be a point in the future, Judge, where he can ask for early termination.
All right. Do you understand if I grant your application for deferred adjudication, if you are unsuccessful or a motion to revoke is filed, then the court could potentially sentence you up to life in prison
Yes, Your Honor.
and a $10,000 fine?
Yes, sir.
Knowing that, are you still asking for deferred adjudication?
Yes, Your Honor.
All right. What do you do for a living for employment?
Right now, I'm working for a demolition company,
And what are your hours?
usually from 7 a.m. till 3:30, sometimes 4:30. And sometimes I'll switch it from day shift to night shift, just depending on the job site.
All right. And the girlfriend that you're living with, who all lives in the household?
Me, her, and her 3 kids,
What are the ages of her 3 children?
15, 16, and 12.
Are these boys, girls?
2 boys and 1 girl.
And how long have you known her before you moved in with her?
About 2 years.
Sorry, just one second.
There's one more thing in the PSI, if I could address, if the court
Yes.
will allow me.
Sure.
They referenced that there was restitution for the testing of the drugs. In one instance, they say that the restitution cost was $6,321. In the other instance, they're saying it was $1,254. I've never experienced those types of numbers when it comes to restitution for drug testing. I don't.
All right, State, do you know how much the restitution is?
Judge,
Those are wide ranges.
It is listed in the PSI specifically, Judge. It just doesn't itemize how, not that they need to, it's just a huge amount.
I'm not sure why it's that amount, Judge. I know typically we just do $57 to SAP or PCSO. Depending on which of the investigating agencies it is.
These were both out of the Bear County Forensic Science.
Right, so what we're going to do is, because the nature of the drugs, who knows, maybe they had to run some different tests. I'm going to order restitution, but we'll have a restitution hearing.
Okay, Judge.
And Ms. Ferguson will give us a date on that. Just give me a moment. Are you on GPS or anything of that nature or no?
Sir?
Are you on GPS or anything?
No, ma'am.
Right.
I do seem to remember, Judge, for the restitution. I think that's maybe why it's so expensive. I think it's expensive to test marijuana now with the changes in the laws the past few years. I think there's a special machine. And
It may be, Judge. I just have never seen those amounts. I appreciate you allowing us to have a restitution hearing. If in the meantime, there's some justification for that, certainly Mr. Ayub would be paying.
All right. We'll have a restitution hearing in regards to that. And State, How long do you anticipate it will take to get your witness? Is there going to be an objection for the witness by Zoom?
No, Your Honor.
Okay. So, and the witness can appear by Zoom?
Yes, ma'am.
And if you will get with the Bear County Lab and see, maybe they have an itemized accounting for the amount.
And it's very possible, Hank may get me that, Judge, and I'll say, oh, okay, that makes sense, and we won't need a restitution hearing. But thank you for giving this opportunity. If we don't need it, I'll inform the court.
All right, there'll be a $500 fine that will be probated. Does anyone wish to speak to the length of the deferred adjudication?
Judge, while the underlying term was 10 years over 10, typically the court, if it is inclined to grant deferred, I know that they tend to grant that similar term. If the state doesn't object, I would welcome a much shorter term for my client.
Well, what term would you be asking for?
Judge, I would leave that up to the discretion of the court. I think if Mr. Ayub is going to mess up, he will do like everybody else, and he messes up fairly early on in their supervision. So 5 years is a pretty long time, Judge. He's in his late 20s, and that's about 20% of his lifetime.
And Judge, I'm right in the middle of doing the TIC, the dismissal forms right now for the judges, or for the causes that were taken into consideration in exchange for this plea, Judge. So the state is respectfully asking for the 10 years if you are inclined to grant deferred.
All right. All right. $500 fine probated, concurrent with County Court Cause number 688261. 9 years deferred adjudication. There's to be regular reporting by Zoom or in person. Random regular UAs. I would say that you could do the patch, but usually on the sites where you're working, since it's demolition, sometimes patches don't adhere very well. But if he wants, we can start off with the patch. And the patches cost more, but it has less time constraints because you just put it on. You don't take it off. I'm sorry, not you put it on. Probation will put it on. And then probation will tell you when it needs to be removed. But when they say it needs to be removed, you need to be specifically there at that time to have it removed. Do you understand?
Yes, Your Honor.
So which would you prefer?
In my understanding, Judge, is the patch alleviates him needing to come in person frequently for testing. Is that the trade-off?
Yes.
Let me see.
However,
let's do the patch, Judge. That'll allow him to work and he won't have to miss work.
All right. I'll say random probation. I'm going to say random regular UAs or the patch. And they'll discuss with you how much the patch costs because it does cost more.
Okay.
200 hours of community service restitution. 150 of those hours will be waived once you complete parenting classes. I'm going to order parenting classes. The remaining hours, they can be paid off to the San Antonio Food Bank at $7.25 per hour, or you can just do the community service hours.
yes, Your Honor. Thank you.
All right, we're off the record. Mr. Ayub, you have decided to date someone who has children, and you are supposed to be someone in their life that they can respect and someone that they can look up to. By doing this, you're not being that person. You're not being a good stepfather if that's what you hope to be in their life. You understand?
Yes, Judge.
You're going to have to do better. All right, good luck to you.
Thank you, Judge.
You're welcome.
A cop takes a stand, but Judge Boyd isn't buying it. What starts as a simple traffic stop spirals into explosive courtroom drama, where one false statement under oath could decide a man's freedom. Did this officer just get caught lying to cover himself?
Court is calling 2024 CR 5244, State of Texas versus Jordan Davis. Can I have parties announced for the record for the state? For the defense?
Good morning, Judge. Alfonso Cabañas for Mr. Davis.
And are you Mr. Davis?
Yes, ma'am.
All right. Mr. Davis, can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jordan Davis.
All right, Mr. Davis, you do realize that you have a right to a jury trial?
Yes, ma'am.
And it's that the court has received a waiver of trial by jury and you're asking to proceed with a bench trial. Is that correct?
Yes, ma'am.
And you understand that means that I will hear whatever evidence is presented and make a decision on whether you're guilty or not guilty?
Yes, ma'am.
Counsel, did you go over this waiver of trial by jury with your client and do you believe he understood it?
Yes, Your Honor, we reviewed it yesterday. He signed it yesterday, and it is his desire to enter into a bench trial.
And state you signed the waiver of a trial by jury as well? All right, the court will find that the waiver of trial by jury has been voluntarily given and signed by the defendant and also signed by the state and the defense. State, you may proceed.
In the name and by authority of the state of Texas, the grand jury of Dare County, state of Texas, duly organized and handled and sworn as such at the March term AE 2024 of the 187th Judicial District Court of said county, in said court at said term, do present in and to said court that in the county and state were said and anterior to the presentment of this indictment on or about the 4th day of March 2024, Jordan Davis, hereinafter referred to as defendant, while using a vehicle, did intentionally flee from a person, namely S. Enriquez, a person the defendant knew was a peace officer who was attempting lawfully to arrest and detain the defendant against the peace and dignity of the state.
How do you plead to that?
Not guilty, Your Honor.
All right. Any opening statements?
Yes, Your Honor, very briefly.
All right, you may proceed.
What the evidence will show is that this is not the most egregious evading in a vehicle case that this court will encounter. The evidence will show that Mr. Davis did not speed egregiously, did not weave in and out of traffic. It will only show that when Deputy Enriquez activated his patrol vehicle's emergency overhead lights to lawfully detain Mr. Davis, that Mr. Davis did not give prompt attention and stop when signaled. That is plain in a vehicle. It's not the worst, but it's still what he did. And after the court hears the evidence, the court should find him guilty of the offense.
Defense, any openings?
Yes, Your Honor. In the rush to judgment, Your Honor, the state gives themselves an added burden, already high burden. For example, whereas the Texas Penal Code 3804, evading arrest or detention, states that.
I'm sorry, just one moment. Excuse me, on the back row? You all are talking too loud and you need to just ask the deputy to move you all to the other end. All right, I'm sorry. Could you start with the code section you're citing, counsel?
Yes, Your Honor. Texas Penal Code 3804 that talks about evading arrest or detention. The code states that a person commits an offense if he intentionally flees from a person he knows is a peace officer or federal special investigator attempting lawfully to arrest or detain him. The added burden that the state has given themselves this morning is that the indictment says, and I'm paraphrasing, a person the defendant knew was a peace officer who was attempting lawfully to arrest and detain him. So the state has to prove beyond a reasonable doubt that this officer had to arrest and detain the defendant. Number one. Number two, Your Honor, you'll see from the video that at no point in time was Mr. Jordan Davis doing anything remotely coming close to evading arrest or detention. Not even fleeing. You'll see from the video that at all times, Mr. Davis was driving either at the speed limit or below. He wasn't weaving within traffic. He wasn't causing any accidents. He wasn't turning off his lights or causing a high speed chase. At one point during the follow, Your Honor, Mr. Jordan Davis goes so much as to turn on the hazard lights to let the officer know where he's at and that he is looking for a place to park. And this is important because you'll see in the video that during the 2 miles that the stop is Mr. Davis is trying to find for a safe place to stop, he's in a construction zone. He's not going or he doesn't stop in an area that's safe to him. He eventually stops in an area that is safe, well lit, and away from traffic. It may not be to the officer's liking that it took him 2 miles to stop, but nonetheless, at no point in time was Mr. Davis doing anything remotely close to fleeing. He wasn't doing anything remotely close to evading arrest or detention. The evidence will show the court that, again, Mr. Davis wasn't speeding, he wasn't weaving, he wasn't driving while intoxicated, he wasn't dashing in through traffic to avoid
the officer, he was simply looking for a safe, well-lit place to stop, which he did.
All right, state, call your first witness.
Big calls Deputy Enriquez.
All right, Deputy Enriquez.
Down in the hall.
All right, thank you. All right, thank you. All right, and everyone, we'll bring you back at 1:30. Oh, if you all would like to, you can take a seat or either we can remain up here. My understanding it's one witness.
I'm fine up here, Your Honor.
All right, thank you. If you'll take a seat, please. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand if you'll state your name for the record, please.
Deputy Stephen Enriquez.
All right, state.
Deputy Enriquez, where are you currently employed?
With the Beard County Sheriff's Office.
Can I get you to take this? Evelyn. And Cindy, do you need a microphone for the? All right, thank you.
Judge, my client.
Oh, you thought you could.
All right, if you all want to sit, you can sit. If you want to stand up here, you can stand up here. All right, state, it's your witness.
Porter, do you need me to repeat my last question?
I have how you employed.
All right, Deputy Enriquez, please answer the last question.
Yes, I'm employed with the Bear County Sheriff's Office
As what?
as a deputy sheriff on patrol.
How long have you been employed with Bear County Sheriff's Office?
Going on 7 years.
And on March 4th, 2024, how were you employed?
As a deputy sheriff on patrol.
And on March 4th, 2024, what were your patrol duties?
Just patrolling the district of Delta 30, which is commonly the Culebra area, searching for crime prevention and responding to calls for service.
The district of Delta 30, is that in Bear County?
Yes, sir.
And what was the time of your patrol?
From 11 p.m. until 7 a.m.
And at approximately 0:35 hours, 35 minutes after midnight, did you see a vehicle that caught your attention?
Yes, sir.
What vehicle was that? If you recall.
Don't recall right now, but I do have the report here, if I can refer back to that.
Please do.
Judge, I would ask the witness be instructed to refresh his memory from the report, not read verbatim.
All right, officer, you're allowed to refresh your memory from the report, but do not read directly from it.
It was a red four-door vehicle.
And what about that vehicle caught your attention?
As it was approaching me, it had its high beams on, and it had 3 lights on instead of all 4.
Which light was not on?
It was the passenger side and the outside.
And was that the headlight?
Yes, sir, correct.
So after perceiving the high beams on and the headlight out, how did you proceed?
I conducted a U-turn as the subject was going the opposite direction of myself, and I proceeded to catch up to that vehicle as it was ahead of another vehicle.
And did you activate your patrol vehicle's emergency overhead lights?
At that time, I did not because it was coming up to a red light, and I didn't want to conduct a traffic stop over the active red light.
What happened next?
I pulled up next to the vehicle just to see if the vehicle had a seatbelt on or anything like that, and I did do a inquiry into the vehicle's license plate.
What did you learn?
Everything was up to date as far as the insurance and the registration. All I had was the defective equipment at that point in time, along with the transportation violation with driving with the high beams on.
Did the light eventually turn green?
Yes, sir, it did. At that point, I got behind the vehicle and activated my emergency lights, which activates my fleet camera.
Now, your fleet camera, does it begin recording when you turn on your emergency or headlights?
It does, but it also records 30 seconds prior with no audio.
Understood. Permission to approach your honor?
Granted.
Deputy. Showing you what is marked in state exhibit 1. Do you recognize this?
Yes, sir, I do.
Can you tell the court what it is?
It's the body-worn camera to my front dash.
And how do you know that it is?
It states it on there along with my signature.
Have you reviewed this? Have you reviewed the contents of this list?
Yes, sir, I have.
And to the best of your knowledge, have there been any alterations or edits to it?
No, sir.
And is it a true and accurate depiction of the events that were recorded by that device on that date?
Yes, sir.
Permission to tender to defense counsel for inspection.
Your Honor, no objection to states number 1.
All right, State's Exhibit number 1 is admitted without objection.
Permission to publish, Your Honor.
Granted.
At this point in the recording, have you activated your emergency overhead light?
Yes, sir, I have.
Did you at any point activate any other signals that indicate to this vehicle that you initiated a detention?
Yes, sir. As it passed multiple spots to pull over, that's when I activated my audible siren just to catch the detention.
Now, I'm stopping here. What to the left of this intersection did you see?
It was an empty road that he could have pulled over to the left or to the right.
Was it lit?
No, sir.
Now, Deputy, do you see these buildings
Yes.
in the recording? What are
Yes. It's a shopping center with a gas station and a McDonald's.
In your opinion, is it well lit?
Yes, sir.
From this intersection, are those buildings accessible to your vehicle?
Yes, sir. There was also an accessible right there between the break and the barriers, so a dirt road to go into that section.
And do you see additional buildings here?
Yes, sir.
Do you know what those buildings were?
That's a car wash.
So the vehicle that you're following turns. Could this vehicle have access these
I'm
buildings?
gonna object to,
to the left or the right?
object to speculation, Your Honor.
Sustained.
Would you have been able to access these buildings to either the left or the right?
Yes, sir.
Now, these buildings to the left, can you tell us what those are?
Those are apartment complexes.
And do you consider this to be a well-lit area based off of what you experienced?
Yes, sir.
Now, these lights here,
Yes, sir.
what is this area?
That's an elementary school.
Was it accessible to you at this intersection?
Yes, sir.
And based on what you can see, is this a well-lit area?
Yes.
Now, what lights do you see on this road?
No.
At this point, have you passed the elementary school?
Yes.
Now, as you turn right at this intersection, what is that?
There's gonna be a subdivision that's barely under construction and another school.
So the subdivision at this time was not yet occupied because its construction was not yet complete.
Correct.
Deputy, what lights do you see?
No.
Oh, do you see lights here?
I see lights to the back. That's a part of another subdivision that's already in the process of being built, and then the school on the right.
But you don't see any street.
No, sir. Correct.
Now, Deputy, did the vehicle eventually come to a stop?
Yes, sir.
Did you contact the operator of that vehicle?
I did it from a distance. At the time, he did not.
Eventually, did he identify himself or did you identify him?
Yes, sir. I did.
Which one?
He identified himself. Once he found out he was under arrest, I did after the name did.
And how did he identify himself?
Vocally.
What did you say his name was?
Jordan is.
And do you see the person that you arrested in the courtroom today?
Yes, sir, I do.
Would you please point that person out by their position in the courtroom and by a particular article of claim?
Sir, he's standing to the left of the judge in a black hat and white shirt.
Thank you. And just to reiterate, all of the events, did they occur in Bear County?
Yes, sir. They did.
Thank you. Pass the witness.
All right, defense.
Thank you, Judge. Officer Enriquez, good morning. Good morning. My name is Alfonso Cabañas. I'm going to be asking you some questions. I'm going to start off by asking you some questions that came about from the state's questions to you, okay?
Yes, sir.
Your Honor, can I go watch the video?
Sure. And the mouse should still be there.
It is, Your Honor.
Thank you. And I'm sorry, Alfonso, do you have on the microphone for the court reporter? Thank you. It's so she can hear it through her headphones.
Yes, sir. Can you hear me? So starting State's Exhibit number 1, officer, at 2 seconds, just to make sure I have my notes correct. At this point in the video, this is the dash cam from your patrol car.
Correct.
Right? And my client's car is to your immediate left.
Yes,
Is that right?
Yes.
Okay. You told the court that, and it's in your report, that the reason for the stop was that my client did not have the 4 headlamps. Is that correct?
Correct. Yes.
Now, which transportation code are you referring to when you're talking about the 4 headlamp
Would
requirement?
be transportation code 547, which would be the maintenance of the equipment. Specifically for the headlights would be 547.333, which is turning off your headlamps from the brightness 500 feet upon approaching another vehicle.
Wait, but let's go on a second because you're jumping the gun a little bit. Your reason for the stop, and according to your testimony, was that my client did not have the 4 headlamps, right? So, and we'll get into the brights in a little bit, but your testimony was that he had 3 functioning headlights, correct?
Yes, sir.
Now, are you familiar with Transportation Code 547.321?
Yes, sir.
Okay, 547.321, correct me if I'm wrong, states that a motor vehicle shall be equipped with at least 2 headlamps. It doesn't talk about 4 or 3, just 2, right? And in Mr. Davis's case, he had not only 2, he had 3 functioning headlights.
Right.
Right? Hold on, we'll get there in a second. Okay, so now that we know he has 3 functioning headlights, okay, your testimony is that you did a U-turn. So in other words, your dash cam recording of these 3 functioning headlamps is not on this dash cam. Correct? Did you not record that?
From the way our dash cam is mounted, there's only 2 ways to activate it. That's by turning on our emergency lights or reaching over, which is across from my computer, and activating it manually.
I get it, but very simply, that wasn't recorded, right? Okay,
Correct.
all right. Now, well, if you look at this video, right here, Officer Enriquez, you told the court that as you drove parallel to my client's car, you were checking to make sure that my client had what he's supposed to when somebody is driving, right?
Yes.
So you correctly stated that my client had a seatbelt on, right? I think you told the court that you ran his license plates, correct?
Correct.
And there was no warrants coming out for him,
Correct.
right? The car rightfully belonged to Mr. Davis, right?
Correct. Actually, no, it belonged to family members.
Family
His mother.
Okay, but it wasn't identified as a stolen vehicle.
Correct.
Right? According to you, the backlights or the tail lamps, excuse me, were working just properly, correct?
Yes, sir.
Okay. And so at this point, I think you also indicated that while you're parallel to him, Mr. Davis is not exceeding the speed limits, correct?
Correct.
He's not weaving in and out of traffic, right? He certainly does not almost hit you or caught you.
Correct.
Okay. All right. Now, starting the video at 2 seconds, now I'm going to try to jump to the parts that the state asked you about. Stopping the video at 1 minute and 47 seconds, Officer Enriquez. This is, according to you, a shopping center to your left.
Correct.
Right? And this also is to the left of the defendant's car.
Correct.
Right? Now, you agree with me that at this point, this area is still considered a construction zone, right?
Not that immediate
Not
area.
the main area,
Correct.
but the area before it was construction zone?
Yes, sir, correct.
Okay. And so to the right of your car, which is also to the right of my client's car, there's nothing but dirt road and no lights.
Correct.
Right? Okay. So starting the video at 1:47, I'm stopping it at 2 minutes and 46 seconds. Officer Enriquez, I may have gone a little bit too far in the video, but again, to your left and to my client's left, we have, is it a car wash or a school?
No, that's a school.
That's a school? Okay, so we passed the car wash,
Yes,
right?
sir, correct.
So the school, car wash, the shopping center, all these three locations were to the left of your vehicle and to the left of my client's vehicle.
Correct.
That's right. To the right of the vehicle, we see nothing, right of my client's vehicle and your vehicle, we see nothing but dirt road and grass and areas that are not well lit or not able for somebody to park. Right?
Officer, I'm gonna show you or hand to you what's been marked as defense exhibit number 1.
Are you familiar with this?
Yes.
Okay, what is it?
Texas Driver Handbook.
Okay.
I'm sorry, could you repeat the last part? You said Texas, and then I didn't hear the second.
The Texas Driver Handbook.
All right, thank you.
In the Texas Driver Handbook, is it published by the Texas Department of Public Safety?
Yes, sir. It's-
Judge, may I approach the state?
Yes.
Judge, while the state confirms that that document is what it is, can I continue my questioning of
Yes.
Officer Enriquez? Okay. Officer Enriquez, while the state continues to review that document, up to this point in the video, at minute 2:46, at this point, you have no reason to arrest. Right? To arrest Mr. Davis, correct?
For the amount that he's been traveling and everything, I would say yes, he's still evading.
Okay. Well, let's backtrack a little bit. Okay. In the transportation code, or even under the evading arrest section, there is no set amount of limit or fees that somebody has to follow before they come to a stop. Correct? Correct. All right. So in other words, just because he's gone 100 feet, 200 feet, there's nothing on the statute, on the Texas Penal Code, or the transportation code that indicates once a defendant is above 100 feet, they committed an offense, right? So up to this point, again, knowing that you check the license plates in the vehicles, you check the inside of the vehicle to make sure that Mr. Davis had a seatbelt on, right? Those are not any traffic offenses, right?
Correct. The traffic offense was practically.
All right, and we'll get to it. And so there's no warrant for him out, correct?
At that time, I don't know who was driving the vehicle.
Okay. There's no speeding either, correct?
Correct.
All right. He's not crossing any of the white tires or anything, correct?
Correct. He's just going to.
All right. Got it?
Yes. Your Honor, I'm going to reject on the basis of relevance.
All right, and you, defense exhibit number 1, that is the Texas Driver Handbook?
Judge, under 8038.
No. Is it the Texas Driver Handbook?
It is, Your Honor.
All right, the state's objection will be overruled. Are you seeking to admit that into evidence, or you are just asking him to review it for demonstratory purposes and for the court to take note of that as a treatise, as you would a treatise?
Judge, I'm going to ask him to read from it, but to address any concerns, under 8038, it's a hearsay exception, and under 9025, it's self-authenticating.
Yes. Yes.
Okay. Thank you, Judge. Okay, Officer Enriquez, so I'm going to show you defense exhibit number 1, particularly
And state if you need to move around to view what the defense is showing the officer, you're more than welcome to.
particularly page 65, that talks about what a driver should do when stopped by law enforcement. Do you see that? Okay. So, and I'm going to read it to you, okay? It says, if you, the driver, are stopped by law enforcement, it is suggested you, number 1, slow down and move the vehicle safely to what side of the road? The right side of the road. The right side of the road. All right. So the school that's on the left car wash is on the left,
Correct.
shopping center is on the left. None of these locations are on the right side of the road.
Correct.
Right? What's on the right side of the road is nothing but dirt, grass, and places that, from a plan's perspective, are not safe to park, correct?
In his perspective.
Okay. Number two, park your vehicle as far to the right of the main traffic lane as possible. Again, to the right, not to the left.
Right.
So you were asking my client, because he did not go to the left, you're asking him to go against this Texas Driver's Handbook.
No,
Right.
I'm just saying those are places that he could have stopped at, along with the shoulder on the right-hand side of the road that we went across for all the way to
And
Courtroom.
we'll get to it. But according to this Texas Driver's Handbook, it only says to move to the right and park to the right.
Right.
Right? It says, if available, park on the right shoulder, right? If unavailable, park on a nearby, well-lighted side street or parking lot away from high volume traffic.
Correct, which he did, yes.
Right, okay, and we'll get to that. So, starting the video at 2:46. One thing I forgot to ask, officer, at this point and for the remainder of the stop, my client turns on his hazard lights.
Correct.
Right? So turning on hazard lights is indicating to you, hey, I'm in front of you. Be careful. I'm right here. Don't run into me. Don't crash into me. He's warning you and other drivers, I'm right here. Right?
Yes, sir. And I
Okay.
had my lights activated.
All right.
Letting him know that I was conducting a traffic
At
stop.
any point during the stop or the follow-up to the traffic stop, did my client turn off his lights?
No, he did.
At any point, did he speed up in excess of the speed limit?
No, he did.
At any point, did he weave within traffic to try to avoid you?
No, he did.
At any point during the stop, did you see him throw anything outside of the window?
No, I didn't.
So while he's following you, while you're following him, you're following not only the car that's right in front of you and never moved or never fled from you, but he also has his hazards on, right? Is that right, sir?
Yes.
Starting the video at 2:49. Now, popping it at 3 minutes and 1 second. If you can see from the video, it's a little bit blurry up here because, but we see that my client is still driving within the lane, and to the right of it, there's what, a sidewalk,
It's a bike lane.
a bike lane?
Yes.
And then next to that bike lane, what's this cement-like structure that's on the road?
It's the sidewalk before that self-storage.
Okay. Starting the video at 3:02. From stopping the video at 3:23, and the 20 seconds that have elapsed, Officer Enriquez, again, we still see the bike lane that you're talking about, to the right of the vehicle, and also the cement sidewalk to the immediate right, that bike lane, right?
Yes.
Thus making it, I guess, unable for my clients to park, correct? With the sidewalk.
Correct.
Starting the video at 3:23. And my client is still in front of you with his hazards, notifying you where he's located.
Yes, sir. In the center of the now.
Okay. Now stopping the video, excuse me, at 3:57, my client goes to his right.
Correct.
Right, to essentially make the right lane, right? Now, what did we say is on the Texas Driver's Handbook, when stopped by law enforcement, it tells the driver to what, slow down?
Slowly be moved to the right.
Which is what my client did. He slowed the vehicle down, right? And then he moved to the right. Is that correct? And it was done in a safe manner. The turn did not hit sidewalk, correct? Playing the video at 3:57. Stopping the video at 4:28. So after he slows down and makes a right turn, Officer Enriquez, my client comes to a stop on this road, correct?
Correct, yes, sir.
What's interesting to note, Officer Enriquez, correct me if I'm wrong, is that there is no traffic on this road, right?
Correct. There was, I believe, like 2 vehicles that did pass. They had to go around. They were blocking the number 2.
Okay. But at this point, because there's no vehicles here at 4:28, right, it's safe for not only the driver, but safe for you to get out of the car. right? And then my last round of questions, officer, is at this point in time, I need to testify to the court that when asked, or when my client was asked by you to identify himself, you had no problem with him identifying himself and then following the order, correct? And the lights, your car's headlights were on, and also, is it your spotter light, what do you refer to that?
Yeah, the spotlight, yeah.
Spotlight, yeah, that was on as well, right? Okay. And then the car that you talked about, right, that other car was to the left of you after, or to the left of that median dividing the roads, right?
Correct, yeah, there was also a car waiting behind us as well.
And then at 4:37 into the video, you see my client speaking what appeared to be his two hands out the car, right?
Correct, yes, sir.
No further questions, Judge.
Any further questions, State?
Mr. Davis, did he make reference to the handbook that Mr. Campagnos just questioned you about?
No, sir, he never did.
Do you have any evidence that he had any knowledge of that handbook or its content?
No, sir.
So whether or not he was obeying its precepts would be speculation.
Correct, yes, sir.
Now, you activated your emergency overhead lights before you reached this intersection.
Yeah, then hoping that we'd pull off and pull.
Did Mr. Davis move into the right-hand lane?
No, sir, he did not.
There were right-hand turn lane.
Yes, sir, yes.
Did Mr. Davis utilize that right-hand turn lane?
No, sir, he did not.
So he had a place where he could have turned right.
I object to speculation, Your Honor.
Gotta be sustained.
Were you capable of turning right and stopping at this intersection if you were of a mind?
Yes,
There a street available here?
yes, sir, to a subdivision.
So you could have turned right at this road,
Yes, sir.
but you didn't
No, sir.
because Mr. Davis.
Correct.
See from that recording. But was that a left turn on the intersection?
No, sir, it was also a right turn as well, so maybe.
So you could have gone right,
Yes, sir, correct.
but you didn't because Mr. Davis did.
Yes, correct.
Now, at this point, does Mr. Davis move into the right-hand lane?
No, sir, it stays in the left.
This intersection, is it possible to turn right?
Yes, sir, there's a high school across the street on the right side.
Did you turn right at this intersection?
No, sir, not.
Is that because Mr. Davis didn't turn right?
Correct.
And yet, what does Mr. Davis do?
He goes left.
Now, what is to Mr. Davis right?
A bike lane and a sidewalk.
Would you have been able to stop here?
Yes, sir, I would have approached from the passenger side.
You didn't stop
No, sir,
because Mr. Davis didn't stop.
correct.
Gone.
It's to a self-storage on the right.
Capable of turning right into that area?
Yes, sir.
So assuming that Mr. Davis was aware of the Texas Driver's Handbook, there were nevertheless multiple areas where he could have turned right,
Correct, yes, sir.
but he didn't.
Correct.
All right, in just one moment, counsel. So all of the attorneys, if you're waiting to see the court, after this witness, the court is taking its break. All right, you may continue.
The center median road.
And occupied the center median lane should he have his
Yes.
that's principle law.
No, sir.
At this point, is there a bicycle lane in your vehicle right?
No, sir.
Improved shoulder?
No, sir.
So no safe place to stop the vehicle except in the middle of the lane.
Yes, correct.
And that's what the operator did.
Yes.
And again, if you see any lights aside from the lights off in the distance,
No, sir.
pass the witness, Your Honor.
All right, defense.
Just one more, Your Honor. Officer Enriquez, probably the video at 0 seconds, for your part to go to my client's immediate right. Stop line, stop, lights. Light turns green and then both vehicles accelerate, right? Correct. Now stopping the video at 20 seconds, you can see that the headlamps on my client's vehicle are illuminating the road just fine, right? Yes, correct. In fact, you see this light that I'm pointing at, it appears to be a light that's, headlamp, it's turned on and working effectively, right?
Yes, so that'd be the time.
So the traffic offering that you claim happened, you have no evidence of it, correct?
As far as the video, no, but I did observe.
Like, you did observe it, there's no video of it. The only video that we can see is your dash cam, which shows that the headlamps are working just fine, correct? Correct. Nothing further, Judge.
All right, any further questions for this witness?
Not from the state, Your Honor.
All right, is this witness excused or subject for recall?
Excuse, Your Honor, I don't plan on.
All right, thank you so much for coming in. You may step down. All right, state, call your next witness. All right, so what I'm going to do, counsel, I know you have federal court. Counsel, we can go off the record. Are you all able to come back tomorrow? You want to come back this afternoon? Because I would like to view the state's exhibit.
I'm good coming back tomorrow if it's okay with the court, so it's not being in a rush to attend the docket and then look at this video.
All right, so what, yes.
I'm here, so you let me go.
Thank you. All right, so what we'll do, Mr. Jordan, we will come back tomorrow. And if you will be here at 9 a.m., that way this evening, I will have a chance to review State's Exhibit number 1 in its entirety. And then I'll come back with my decision.
Yes, ma'am.
All right, is there anything else?
Not from defense counsel, Judge.
All right, thank you so much for dressing appropriately for.
Hi.
Okay. All both rest and close, State,
Yes, Your Honor.
defense.
Rest and close, Your Honor.
All right, thank you so much. All right, once you sign the reset form, you're excused. You're welcome. And court is calling 2024 CR 5244, State versus Jordan Davis. Do I have parties announced for the record for the state? Defense.
Good afternoon, Judge. Alfonso Cabañas for Mr. Jordan Davis.
And are you Mr. Davis?
Yes, ma'am.
All right, you all had a bench trial with the court, and the court, after both parties had rested and closed, the court asked for an opportunity to view State's Exhibit 1 in its entirety. The court did have a chance to review State's Exhibit 1 in its entirety, so the court will hear closing arguments. State?
Your Honor, does the state typically not give closing arguments in trial following the defense?
If they want to. My understanding from speaking with you off the record that the defense didn't really want to do a closing. So that's why I was asking you for your closing. But if that's,
I don't know whether defense counsel wanted to or not. But
all right, defense, do you want to get closing?
Yes, Your Honor.
Okay, then I'll hear your closing.
Thank you, Judge. Judge, as the court was aware during cross-examination a couple of days ago, the only officer that stopped Mr. Davis testified that the alleged traffic offense, that he saw being committed was not recorded. I asked him when I talked and described as to the reason for the stop, he initially said, well, his headlamps were turned off, or he didn't have the number of requisite headlamps as per the transportation code. When he confirmed on the stand that as per the transportation code, my client had more than 2, he had 3 functioning headlamps, so much so that during the video, if the court recalls, the officer testifies that the headlamps in my client's car were working. Therefore, Judge, we have testimony from the officer that the alleged traffic offense of not having any functioning headlights is completely false. Secondly, Judge, after we move on from that point, the officer goes on a narrative in which he's trying to tell the court what he, the officer, would do in this situation. The transportation code and the penal code don't read that way. The transportation code and the penal code read that my client or the individual who's alleged to have been committing an evading offense
needs to be clearly shown as evading law enforcement. If the court recalls from the video, during the entire length of the officer following my client doesn't speed, doesn't turn off his lights, does not drive in excess of the speed limit, does not drive under the speed limit, does not avoid traffic, does not flee from the officer. Additionally, my client goes so much as to take the extra step and notify the officer by turning on his hazard lights. The officer makes it a point to say that there were multiple shopping locations or shopping centers on the left side of the highway in which my client could have turned. Well, Judge, then I questioned the officer on Texas DPS, the driving manual, which states that when being followed by law enforcement, a driver has to stop, or rather must go to the right and stop in a place that's well lit and safe, not only for himself, but law enforcement behind him. So when I questioned the officer as to whether or not my client could have stopped on the right, being that it's a construction zone, being that there was nothing but grass and dirt and it was not lit, the officer said, well, I don't know, but I could have stopped there. As we proceed through the stop, or through the video, Your Honor, again, you continue to see that at no point in time did my client commit any additional traffic offenses other than the alleged traffic offense, which again was not recorded. The officer testified that my client was driving a vehicle that was not stolen. He was driving a vehicle with a seatbelt on. There was nothing that my client was doing as he was driving that warranted a traffic stop. As the officer continues to follow my client with his hazard lights turns to the right as he should, and then parks in an area where the officer testified there's no cars coming back and forth, thereby making it safe for my client and law enforcement to continue this interaction. And so the point of this, Your Honor, is that at no point in time did my client evade any arrest or detention. My client simply drove to find a place to stop. We know that he did not flee. We know that he didn't even intend to evade arrest or detention. He was simply looking for a safe place to stop. And as he was doing so, he notified the officer behind him by turning his hazard lights and maintaining a safe rate of speed. And for those reasons, Your Honor, I ask the court to find my client not guilty of the offense of evading arrest or detention.
All right. State.
Defense counsel's arguments are well made, but at certain points logically inconsistent and at other points irrelevant. Mr. Cabañas points out that the deputy's testimony was that Mr. Davis had 3 headlights on. Now, if Mr. Cabañas means this to mean that the high beams were on, then Mr. Davis committed an offense by having his high beams on within 300 feet of oncoming traffic, in which case Mr. Davis committed an offense of the transportation code.
Was there oncoming traffic?
There was, Your Honor. And
okay.
We'll be able to see it from the officer's dash cam recording. So Deputy Enriquez did have reasonable suspicion to detain the vehicle. Moreover, case law is clear. Under Lopez v. State, the Court of Appeals for San Antonio stated that although the officers agreed that Lopez was not accelerating from them or driving recklessly after exiting the highway, fleeing is anything less than prompt compliance with an officer's direction to stop, and fleeing slowly is still fleeing. So the fact that Mr. Davis did not speed or travel under the speed limit, the fact that he did not weave in and out of traffic, the fact that he was wearing his seatbelt, these are all very interesting assertions, but they are not relevant to the court's determination of whether he evaded arrest or detention. Finally, there's been no evidence introduced that Mr. Davis was actually following the Texas DPS handbook. There's been no evidence introduced that he's ever read it. There's been no evidence introduced that he was even vaguely aware of it. And so Mr. Cabañas' reliance on this Texas DPS handbook is misplaced, because there's no evidence that Mr. Davis was actually following its advice. Even if he were, there were multiple areas for Mr. Davis to stop. The area in which he stopped was not a well-lit place. Deputy Enriquez testified that after the vehicle came to a stop, other vehicles had to go around it. And it's because where Mr. Davis stopped was on a 2-lane road with no bike lane or improved shoulder for him to move into. And so the only place that he could stop was in the lane. So for those reasons, the court should find him guilty.
All right, so you're saying that there is no proof that he knew what was in the Texas Driver's Handbook, and therefore that should be disregarded? The officer's testimony on with regards to the Texas Driver's Handbook?
The officer's testimony is not evidence that Mr. Davis.
No, that's what I'm saying. You're saying that there's no evidence that he knew about the rules for the Texas Driver's Handbook.
Correct.
And how is that relevant? Because the defense doesn't have to present any evidence, correct?
Correct. The defense does not need to present any evidence. But if the defense wants to rely on this DPS handbook for the proposition that Mr. Davis was obeying its advice, then there should be some evidence that he was at least aware of it, much less that he read it and that he obeyed it. And there's been no evidence.
All right. All right, the court has reviewed State's Exhibit number 1 in its entirety. I've heard both parties' argument. As both parties are aware, argument is not testimony, it's not the law, it's just your argument. After reviewing everything, listening to the testimony and seeing State's Exhibit number 1, the court will find the defendant not guilty. Is there anything else from either side?
Not from defense counsel.
Okay, thank you. If you will give this to the court reporter, please.
Yes, Your Honor.
Thank you for dressing appropriately for court.
Thank you, Your Honor. That's